We often talk about trade disputes with other countries, but one's been brewing right here in this country. There are a number of barriers to trade between the provinces, like a New Brunswick man that just wanted cheaper beer. He took his fight to the Supreme Court of Canada, but today was denied in a landmark ruling. 5 years ago, the RCMP stopped Gerard Comeau at the New Brunswick and Quebec border. He was fined more than $292 for violating the New Brunswick Liquor Control Act. He had 14 cases of beer, 2 bottles of whiskey, and a bottle of liqueur in his trunk. He bought his haul in Pointe-à-la-Croix, Quebec, where it was cheaper. But the maximum amount of alcohol an individual can bring into the province is 12 pints of beer or 1 bottle of wine or spirits. The Supreme Court of Canada says provinces and territories have the constitutional right to restrict the import of goods from each other as long as the primary aim of the restriction is not to impede trade. Now, clearly, the case has potentially far-reaching implications for interprovincial trade, for the economy, and, of course, for consumers' choice. It could lead to a host of other rather bizarre restrictions being re-examined, like in Ontario, where visitors can't take bullfrogs for sale or barter, Quebec, where you have to live in the province for at least a year before becoming a funeral director, and in Nova Scotia, which reserves the right to limit fur harvesting licenses to its residences. Now, the man at the center of this case, Gerard Comeau, spoke with CBC News earlier. He said the ruling comes as a surprise.
Sense, because you can go in Quebec or any provinces and buy any quantity of merchandise, clothes, shoes, anything, except for beer.
To talk about the implications of today's Supreme Court decision, we have Derek Frum in Calgary. He's a lawyer with the Canadian Constitution Foundation, the group that helped finance Gerard Comeau's case. First of all, sir, just give us your broad thoughts. What do you make of this decision?
Well, to be honest, I am disappointed with the decision. I thought that the Supreme Court had a historic opportunity to actually set the record straight and implement the Constitution as it was originally intended to be implemented in the country of Canada.
Section 121 of the Canadian Constitution reads, and I'll quote it here, "All articles of the growth, produce, or manufacture of any one of the provinces shall from and after the Union be admitted free into each of the other provinces." That sounds pretty clear to me. You're a lawyer. The court disagrees with that. What is the actual decision here? How did this come to be?
Well, it sounds very clear to me, too, particularly the bit that says admitted free, even though the court did go on a bit today about how the phrase admitted free is ambiguous. But what this, I think, is based upon is the case law that has led us to the point where we're at today. See, early on, Section 121 of the Constitution Act, 1867, that you just read, was encumbered by a decision called Gold Seal. And in Gold Seal, the court decided that tariff barriers were offline, but non-tariff barriers were okay. So, for instance, a tariff barrier would be a fee assessed upon volume, weight, something of the like, where a non-tariff barrier could be inspections or various bottling sizes, different restrictions like that, or regulations of that variety. So Gold Seal found that tariff barriers were contra Section 121. Non-tariff barriers were perfectly fine. Now, when you go back and look at the text of 121, it's really hard to find that distinction between tariff and non-tariff in there. Now, later on, there was a decision called Murphy, and what Murphy did was it tweaked that a little bit. And so that any sort of barrier that is between provinces that has as its purpose keeping out the goods from another province, if that is its primary purpose, then it runs afoul of Section 121. So what the court did today is it just frankly stamped its foot and said, we're going to follow the precedents of the past.
The New Brunswick government's argument in this was, if I dare say, kind of apocalyptic. They said, they warned the Supreme Court in its written argument that the case Mr. Comeau was proposing, quote, an end to Canadian federalism as it was originally conceived. This clearly would have been disruptive. Would it have been that disruptive?
No, not at all. And that sort of hyperbole has never really been that helpful in any sort of legal case such as this one. For instance, what a province is allowed to do is to tax things. And if they needed to raise revenues, which is part of their argument, that they needed to be able to raise revenues, and if Comeau won his case, then somehow they would be unable to do so on liquor. Well, all they would need to do is tax liquor directly instead of have the sort of massive regulatory system they have in their monopoly for liquor right now. So it would have required some adjustment on their part, but revenues could still be raised. It's not as if the sky, as you said, would have fallen. It's not apocalyptic.
I want to get to whether there's a way around this, because the frustration is so palpable when we speak on this program with manufacturers, wine manufacturers, beer manufacturers that want to get their goods to market and know that you can do business more easily with Belgium than you can with another province in this country. What is the next step? Is this a political decision that needs to get tackled? What needs to happen?
Well, it seems to me that it is a political decision. And I think the most fair reading of this case is that we have the Supreme Court saying we need to get rid of this hot potato and send it back to the legislatures throughout the country. They need to resolve their differences. Now, the problem, as I see it with that, is it's wonderful that we can vote in different governments as voters. We can express our views that way. If we don't like the protectionist policies of one province, say Alberta, then we can find a new government in this province by voting. But the problem to me is that the Constitution is now close to 151 years old, and this provision has been there for that entire period of time. And it says the words admitted free, and it has the entire time. And we've gotten very little results. In fact, as you said, when you talk to entrepreneurs and business people throughout the country, they're frustrated, and this decision will not do anything to alleviate their frustration. And I'm not sure that we can trust our elected officials to resolve this, because they haven't done so far. Why would they do it now?
Indeed. Thanks for your insights into the law behind this. Derek Frum in Calgary is a lawyer with the Canadian Constitution Foundation.